Alright guys, my name is Moses. This is Moses Learns Law. Today I'm going to be reading the UCC Article 1, General Provisions. I think I'm just going to go through the whole Article 1. I might break up these different articles into different videos, or I might group them together. We'll see. But right now I'm going to just start with Article 1. 101, short titles. This act may be cited as the Uniform Commercial Code. This article may be cited as Uniform Commercial Code, General Provisions. And sorry if I have a lisp, I have my retainers in. So C's and S's, it's going to be a little issue, but you know, we got to work through it, get these straight teeth. So 102, scope of article. This article applies to a transaction to the extent that it is governed by another article of the Uniform Commercial Code. 103, construction of Uniform Commercial Code to promote its purposes and policies. Applicability of supplemental principles of law. Construction of Uniform Commercial Code to promote its purposes and policies. Applicability of supplemental principles of law. The Uniform Commercial Code must be liberally construed and applied to promote its underlying purposes and policies, which are 1. To simplify, clarify, and modernize the law governing commercial transactions. 2. To permit the continued expansion of commercial practices through custom, usage, and agreement of the parties. And 3. To make uniform the law among the various jurisdictions. B. Unless displaced by the particular provisions of the Uniform Commercial Code, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating cause supplement its provisions. 104. Construction against implied repeal. The Uniform Commercial Code being a general act intended as a unified coverage of its subject matter, no part of it shall be deemed to be impliedly repealed by subsequent legislation if such construction can reasonably be avoided. 105. Severability. If any provision or clause of the Uniform Commercial Code or its application to any person or circumstance is held invalid, the invalidity does not affect other provisions or applications of the Uniform Commercial Code, which can be given effect without the invalid provision or application, and to this end, the provisions of the Uniform Commercial Code are severable. So it's always good, guys, when we are reading these, just to click the blue hyperlinks, because it is, different language. It is English, but when they're talking here in these codes and these laws and these Uniform Commercial Codes and, things like that, their definitions might be, a little bit different. So it's always good to click these to see what these all mean, and we'll get into that after this Article 1 in the 100s when we get to the 200s. So I did click on the word person, which means individual, corporation, business trust, estate, trust, partnership, limited liability company, association, joint venture, government, governmental subdivision, agency or instrumentality, public corporation, or any other legal or commercial entity. So normally, when we talk about a person, we think mom, dad, brother, a person, individual, but here, when we're talking about, in commerce and things like that, person means all of these. So in their contract or any type of document, if they refer to a person, it could be any of these. So we just have to be careful of that. All right, 106, use of singular and plural gender. In the Uniform Commercial Code, unless the statutory context otherwise requires, 1. Words in the singular number include the plural, and those in the plural include the singular. And 2. Words of any gender also refer to any other gender. 107. Section captions. Section captions are part of the Uniform Commercial Code. 108. Relation to electronic signatures in Global and National Commerce Act. This article modifies, limits, and supersedes the Federal Electronic Signatures in Global and National Commerce Act, 15 U.S.C. Section 7001 ETSEQ, except that nothing in this article modifies, limits, or supersedes Section 7001C of that act or authorizes electronic delivery of any of the notices described in Section 7003B of that act. All right, looks like we're on part 2 now. So this is where we're going to go ahead and get into the definitions. So unless the context otherwise requires, words or phrases defined in this section or in the additional definitions contained in other articles of the Uniform Commercial Code that apply to particular articles or parts thereof have the meanings stated. Subject to definitions contained in other articles of the Uniform Commercial Code that apply to particular articles or parts thereof. So, number 1, action. In the sense of a judicial proceeding includes recoupment, counterclaim, set-off, suit in equity, and any other proceeding in which rights are determined. Number 2, aggrieved party means a party entitled to pursue a remedy. Agreement, as distinguished from contract, means the bargain of the parties in fact, as found in their language or inferred from other circumstances, including course of performance, course of dealing, or usage of trade as provided in Section 1303. Bank means a person. See, look at that. And you have the hyperlink there. So person means individual, entity, corporation, blah, blah, blah. Bank means a person engaged in the business of banking and includes a savings bank, savings and loan association, credit union, and trust company. Bearer means a person, once again, means a person in possession of a negotiable instrument, document of title, or certificated security that is payable to bearer or endorsed in blank. Bill of lading means a document evidencing the receipt of goods for shipment issued by a person engaged in the business of transporting or forwarding goods. Branch includes a separately incorporated foreign branch of a bank. Burden of establishing. A fact means the burden of persuading the trier of fact that the existence of the fact is more probable than its non-existence. Buyer in ordinary course of business. Stand on business. Buyer in ordinary course of business means a person that buys goods in good faith without knowledge that the sale violates the rights of another person in the goods, and in the ordinary course from a person other than a pawnbroker in the business of selling goods of that kind. A person buys goods in the ordinary course if the sale to the person comports with the usual or customary practices and the kind of business in which the seller is engaged, or with the seller's own usual or customary practices. A person that sells oil, gas, or other minerals at the wellhead or minehead is a person in the business of selling goods of that kind. A buyer in ordinary course of business may buy for cash by exchange of other property or on secured or unsecured credit, and may acquire goods or documents of title under a pre-existing contract for sale. Only a buyer that takes possession of the goods or has a right to recover the goods from the seller under Article 2 may be a buyer in ordinary course of business. Buyer in ordinary course of business does not include a person that acquires goods in a transfer in bulk or as security for or in total or partial satisfaction of a money debt. Conspicuous, with reference to a term, means so written, displayed, or presented that a reasonable person or company against which it is to operate out to have noticed it. So let's just take a break there. So in your contracts, or when a company has to, give you your disclosures, those have to be conspicuous. And for the most part, they're really not. Even though most of us, when we get our applications or contracts or things like that, we don't really tend to read them. I do now, but usually, we go right to the signature part. We might glaze over, act like we're reading it, but we're really not. But even if, when you go back to look at your contracts, there's supposed to be certain disclosures in there, um, things that you might have missed, that clearly, when we go over these here, have to be in there, and they're not conspicuous at all. So it says whether a term is conspicuous or not is a decision for the court. Conspicuous terms include the following: A heading in capitals equal to or greater in size than the surrounding text, or in contrasting type, font, or color to the surrounding text of the same or lesser size. And B, language in the body of a record or display in larger type than the surrounding text, or in contrasting type, font, or color to the surrounding text of the same size, or set off from surrounding text of the same size by symbols or other marks that call attention to the language. Consumer means an individual who enters into a transaction primarily for personal, family, or household purposes, not for commerce, not for hire, not for business, for personal, family, or household purposes. Contract, as distinguished from agreement, means the total legal obligation that results from the parties' agreement as determined by the Uniform Commercial Code, as supplemented by any other applicable laws. Includes a general creditor, a secured creditor, a lien creditor, and any representative of creditors, including an assignee for the benefit of creditors, a trustee in bankruptcy, a receiver in equity, and an executor or administrator of insolvent debtors or assigner's estate. Defendant includes a person in the position of defendant in a counterclaim, cross-claim, or third-party claim. Delivery, with respect to an instrument, document of title, or chattel paper, means voluntary transfer of possession. Document of title includes bill of lading, dock warrant, dock receipt, warehouse receipt, or order for the delivery of goods, and also any other document which in the regular course of business or financing is treated as adequately evidencing that the person in possession of it is entitled to receive, hold, and dispose of the document and the goods it covers. To be a document of title, a document must purport to be issued by or addressed to a bailee, and might be saying that wrong. A bailee, and purport to cover goods in the bailee's possession, which are either identified or fungible portions of an identified mass. Little tongue twisters there. Fault means a default, breach, or wrongful act or omission. Fungible goods means A, goods of which any unit by nature or usage of trade is the equivalent of any other like unit, or B, goods that by agreement are treated as equivalent. Genuine means free of forgery or counterfeiting. Good faith, except as otherwise provided in Article 5, means honesty in fact and the observance of reasonable commercial standards of fair dealing. So when we usually go buy things, we're usually doing things in good faith. Holder means the person in possession of a negotiable instrument that is payable either to bearer or to an identified person that is the person in possession, or B, the person in possession of a document entitled, if the goods are deliverable, either have to be bearer or to the order of the person in possession. Insolvency proceeding includes an assignment for the benefit of creditors or other proceeding intended to liquidate or rehabilitate the estate of the person involved. Insolvent means A, having generally ceased to pay debts in the ordinary course of business other than as a result of bona fide dispute. B, being unable to pay debts as they become due, or C, being insolvent within the meaning of federal bankruptcy law. Money means a medium of exchange currently authorized or adopted by a domestic or foreign government. The term includes a monetary unit of account established by an intergovernmental organization by agreement between two or more countries. Organization means a person other than an individual. Party, as distinguished from third party, means a person that has engaged in a transaction or made an agreement subject to the Uniform Commercial Code. Person means an individual, corporation, business, trust, estate, trust, partnership, limited liability company, association, joint venture, government, governmental subdivision, agency, or instrumentality, public corporation, or any other legal or commercial entity. Present value means the amount as of a date certain of one or more sums payable in the future, discounted to the date certain by use of either an interest rate specified by the parties if the rate is not manifestly unreasonable at the time the transaction is entered into, or if an interest rate is not so specified, a commercially reasonable rate that takes into account the facts and circumstances at the time the transaction is entered into. Purchase means taking by sale, lease, discount, negotiation, mortgage, pledge, lien, security interest, issue or reissue, gift, or any other voluntary transaction creating an interest in property. So look, but gift is crazy. Gift is kind of crazy. Like, what do they mean a gift? So if I'm purchasing a car, it's a gift. That's crazy. Or any other voluntary transaction creating an interest in property. Purchaser means a person that takes by purchase. Record means information that is inscribed on a tangible medium that is stored in an electronic or other medium and is retrievable in perceivable form. Remedy means any remedial right to which an aggrieved party is entitled with or without resort to a tribunal. Representative means a person empowered to act for another, including an agent, an officer of a corporation or association, and a trustee, executor, or administrator of an estate. Right includes remedy. Security interest means an interest in personal property or fixtures which secures payment or performance of an obligation. So when we look at our car contracts or any contract, they usually have this in here. They always say it secures the collateral for the asset or some bullshit like that. So it says it means an interest in personal property. So if I'm going to go purchase a car, the company itself says when we sign the contract, we are giving them an interest in our personal property or fixtures. So let's break this down. We are giving them a right. We're giving them an interest in our own personal property that secures the payment or performance of an obligation. So if they have an interest in our own personal property, what would their performance of an obligation be? I'm keep reading. All right, so security interest includes any interest of a cosigner and a buyer of accounts, chattel paper, a payment intangible, or a promissory note in a transaction that is subject to Article 9. Security interest does not include the special property interest of a buyer of goods on identification of those goods to a contract for sale under Section 2505, the right of a seller or lessor of goods under Article 2 or 2A to retain or acquire possession of the goods is not a security interest, but a seller or lessor may also acquire a security interest by complying with Article 9. The retention or reservation of title by seller of goods notwithstanding shipment or delivery to the buyer under Section 2401 is limited in effect to a reservation of a security interest. Whether a transaction in the form of a lease creates a security interest is determined pursuant to Section 1203. Send, in connection with a writing, record, or notice, means to deposit in the mail or deliver for transmission by any other usual means of communication with postage or cost of transmission provided for and properly addressed, and, in the case of an instrument, to an address specified thereon or otherwise agreed, or if there be none to any address reasonable under the circumstances, or B, in any other way to cause to be received any record or notice within a time it would have provided if properly sent. It's 2:47 a.m. by the way. Really locked in for real. All right. So sign includes using any symbol executed or adopted with present intention to adopt or accept a writing. State means a state of the United States, the District of Columbia, Puerto Rico, the United States Virgin Islands, or any territory or insular possession subject to the jurisdiction of the United States. It's crazy how they don't say state of the United States of America. They just say means a state of the United States. Surety includes a guarantor or any other secondary obligor. Term means a portion of an agreement that relates to a particular matter. Unauthorized signature means a signature made without actual implied or apparent authority. The term includes a forgery. Warehouse receipt means a receipt issued by a person or business engaged in the business of storing goods for hire. Writing includes printing, typewriting, or any other intentional reduction to tangible form. Written has a corresponding meaning. All right, so we're out these freaking definitions. Holy cow, that was a lot. Excuse me. All right, so we're on 202, notice, which is knowledge. A. Subject to subsection F, a person has notice of a fact if the person, 1, has actual knowledge of it, 2, has received a notice or notification of it, or 3, from all the facts and circumstances known to the person at the time in question, has reason to know that it exists. B. Knowledge means actual knowledge. Knows has a corresponding meaning. Discover or learn, or words of similar import refer to knowledge rather than to reason to know. I'm telling you, some tongue twister shit right here. A person notifies or gives a notice or notification to another person or business by taking such steps as may be reasonable required to inform the other person or business in ordinary course whether or not the other person or business actually comes to know of it. Okay. E. Subject to subsection F, a person receives a notice or notification when 1, it comes to that person's attention, or 2, it is duly delivered in a form reasonable under the circumstances at the place of business through which the contract was made, or at another location held at by that person as the place of receipt of such communications. Mail. Notice, knowledge, or a notice or a notification received by an organization is effective for a particular transaction from the time it is brought to the attention of the individual conducting that transaction, and in any event, from the time it would have been brought to the individual's attention if the organization had exercised due diligence. An organization exercises due diligence if it maintains reasonable routines for communicating significant information to the person conducting the transaction, and there is reasonable compliance with the routines. Due diligence does not require an individual acting for the organization to communicate information unless the communication is part of the individual's regular duties, or the individual has reason to know of the transaction and that the transaction would be materially affected by the information. All right, 203, lease distinguished from security interests. Whether a transaction in the form of a lease creates a lease, whether a transaction in the form of a lease creates a lease or security interest is determined by the facts of each case. B. A transaction in the form of a lease creates a security interest if the consideration that the lessee is to pay the lessor for the right to possession and use of the goods is an obligation for the term of the lease and is not subject to termination by the lessee, and 1, the original term of the lease is equal to or greater than the remaining economic life of the goods. 2, the lessee is bound to renew the lease for the remaining economic life of the goods, or is bound to become the owner of the goods. The lessee has an option to renew the lease for the remaining economic life of the goods for no additional consideration or for nominal additional consideration upon compliance with the lease agreement. Or 4, the lessee has an option to become the owner of the goods for no additional consideration or for nominal additional consideration upon the compliance within a lease agreement. That's interesting. C. A transaction in the form of a lease does not create a security interest merely because 1. The present value of the consideration the lessee is obligated to pay the lessor for the right to possession and use of the goods is substantially equal to or is greater than the fair market value of the goods at the time the lease is entered into. The lessee assumes risk of the loss of the goods. The lessee agrees to pay with respect to the goods taxes, insurance filing, recording or registration fees, or service or maintenance costs. The lessee has an option to renew the lease or to become the owner of the goods. It does not create a security interest if the lessee has an option to renew the lease for a fixed rent that is equal to or greater than a reasonable predictable fair market rent for the use of the goods for the term of the renewal at the time the option is to be performed. Or 6, the lessee has an option to become the owner of the goods for a fixed price that is equal to or greater than the reasonable predictable fair market value of the goods at the time the option is to be performed. Additional consideration is nominal if it is less than the lessee's reasonable predictable cost of performing under the lease agreement if the option is not exercised. Additional consideration is not nominal if 1. When the option to renew the lease is granted to the lessee, the rent is stated to be fair market rent for the use of the goods for the term of the renewal determined at the time the option is to be performed. Or 2, when the option to become the owner of the goods is granted to the lessee, the price is stated to be the fair market value of the goods determined at the time the option is to be performed. The remaining economic life of the goods and a reasonable predictable fair market rent, fair market value, or cost of performing under the lease agreement must be determined with reference to the facts and circumstances at the time the transaction is entered into. So don't be trying to renege. You know what I'm saying? 204, value. Except as otherwise provided in Article 3, 4, and 5, and 6, a person gives value for rights if the person acquires them. 1. In return for a binding commitment to extend credit or for the extension of immediately available credit, whether or not drawn upon, or whether or not a chargeback is provided for in the event of difficulties in collection, as security for in a total or partial satisfaction of a pre-existing claim. 3. By accepting delivery under a pre-existing contract for purchase. Or 4. In return for any consideration sufficient to support a simple contract. 205, reasonable time, seasonableness. Okay, never heard of that word. A, whether a time for taking an action required by the Uniform Commercial Code is reasonable depends on the nature, purpose, and circumstances of the action. B, an action is taken seasonably if it is taken at or within the time agreed, or if no time is agreed at or within a reasonable time. 206, presumptions. Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. Steep. All right, so we're on part 3. Territorial applicability and general rules. Territorial applicability. Parties' power to choose applicable law. A, except as otherwise provided in this section, when a transaction bears a reasonable relation to the state and also to another state or nation, the parties may agree that the law either of this state or of such other state or nation shall govern their rights and duties. B, in the absence of an agreement effective under subsection A, and except as provided in subsection C, the Uniform Commercial Code applies to transactions bearing an appropriate relation to this state. C, if one of the following provisions of the Uniform Commercial Code specifies the applicable law, that provisions governs in a contrary agreement is effective only to the extent permitted by the law so specified. 1 section, I'm not going to read all those. 302, variation by agreement, except as otherwise provided in subsection B or elsewhere in the Uniform Commercial Code. The effective provisions of the Uniform Commercial Code may be varied by agreement. B, the obligations of good faith, diligence, reasonableness, and care prescribed by the Uniform Commercial Code may not be disclaimed by agreement. The parties by agreement may determine the standards by which the performance of those obligations is to be measured if those standards are not manifestly unreasonable. Whenever the Uniform Commercial Code requires an action to be taken within a reasonable time, a time that is not manifestly unreasonable may be fixed by agreement. C. The presence in certain provisions of the Uniform Commercial Code of the phrase "unless otherwise agreed" or words of similar import does not imply that the effect of other provisions may not be varied by agreement under this section. 303. Course of performance, course of dealing, and usage of trade. A course of performance is a sequence of conduct between the parties to a particular transaction that exists. If 1. The agreement of the parties with respect to the transaction involves repeated occasions for performance by a party, and 2. The other party, with knowledge of the nature of the performance and opportunity for objection to it, accepts the performance or acquiescence in it without objection. So I'm pretty sure acquiescence, like they go along with it. Quote me if I'm wrong in the comments. B. A course of dealing is a sequence of conduct concerning previous transactions between the parties to a particular transaction that is fairly to be regarded as establishing a common basis of understanding for interpreting their expressions and other conduct. C. A usage of trade is any practice or method of dealing having such regularity of observance in a place, vocation, or trade as to justify an expectation that it will be observed with respect to the transaction in question. The existence and scope of such a usage must be proved as facts. If it is established that such a usage is embodied in a trade code or similar record, the interpretation of the record is a question of law. D. A course of performance or course of dealing between the parties of usage of trade and the vocation or trade in which they are engaged or of which they are or should be aware is relevant in ascertaining the meaning of the parties' agreement, may give particular meaning to specific terms of the agreement, and may supplement or qualify the terms of the agreement. A usage of trade applicable in the place in which part of the performance under the agreement is to occur may be so utilized as to that part of the performance. E. Except as otherwise provided in subsection F, the express terms of an agreement and any applicable course of performance, course of dealing, or usage of trade must be construed whenever reasonable as consistent with each other. If such a construction is unreasonable, 1. Express terms prevail over course of performance, course of dealing, and usage of trade. 2. Course of performance prevails over course of dealing and usage of trade. And 3. Course of dealing prevails over usage of trade. F. Subject to Section 209, a course of performance is relevant to show a waiver of modification of any term inconsistent with the course of performance. And G, evidence of a relevant usage of trade offered by one party is not admissible unless the party has given the other party notice that the court finds sufficient to prevent unfair surprise to the other party. Obligation of good faith. Every contract or duty within the Uniform Commercial Code imposes an obligation of good faith in its performance and enforcement. The remedies provided by the Uniform Commercial Code must be liberally administered to the end that the aggrieved party may be put in as a good position as if the other party had fully performed, but neither consequential or special damages nor penal damages may be had except as specifically provided in the Uniform Commercial Code or by other rule of law. B. Any right or obligation declared by the Uniform Commercial Code is enforceable by action unless the provision declaring it specifies a different and limited effect. 306. Waiver of Renunciation of claim or right after breach. A claim or right arising out of an alleged breach may be discharged in whole or in part without consideration by agreement of the aggrieved party and an authenticated record. 307. Prima facie evidence by third-party documents. Fact check me on that word too in the comments. Document in due form purporting to be a bill of lading, policy or certificate of insurance, official weighers or inspector certificate, consular invoice, or any other document authorized or required by the contract to be issued by a third party is prima facie evidence or its own authenticity and genuineness of the facts stated in the document by the third party. 308. Performance or acceptance under reservation of rights. So this is how we should be signing. You don't ever want to waive your rights. You always want to reserve them. For those that don't reserve your rights, it is already assumed that you waived your rights. So you always have to reserve them. A party with the explicit reservation of rights performs or promises performance or assents to performance in a manner demanded or offered by the party does not thereby prejudice the rights reserved. Such words as without prejudice, under protest, or the like are sufficient. B. Subsection A does not apply to an accord and satisfaction. Okay. 309. Option to accelerate at will. A term providing that one party or that party's successor in interest may accelerate payment or performance or require collateral or additional collateral at will, or when the party deems itself insecure, or words of similar import means that the party has power to do so only if that party in good faith believes that the prospect of payment or performance is impaired. The burden of establishing lack of good faith is on the party against which the power has been exercised. Subordinated obligations. An obligation may be issued as subordinated to performance of another obligation of the person obligated, or a creditor may subordinate its right to performance of an obligation by agreement with either the person obligated or another creditor of the person obligated. Subordination does not create a security interest as against either the common debtor or a subordinated creditor. All right. So that is the end of Article 1. Interesting read. Some of those words I have never seen before in my life. But it is interesting. So next vid, we're just going to go ahead and do the read through for Article 2. And thanks for tuning in, guys. And we'll be back with Moses Learns Law. Thanks.